All rise. The Court of Appeals, Division 1, is now in session.
Thank you. Please be seated. This is a time set for oral argument in Gilmore versus Gallego, our case number CV220049. Each side is allocated 20 minutes for argument. Appellant, you may wish to reserve a portion of your time. If you wish to do so, you need to keep track of your own time at the clock at the podium. Out of respect for counsel and to avoid any embarrassment, please make sure those who are in attendance that your phone is off or turned to mute so our proceedings are not being interrupted. We've read the briefs, we've conferenced the case. We'd encourage you to keep that in mind as you present oral argument to us today. Our proceedings are being recorded and will be posted to YouTube in due course. So please, as you begin your argument, start by telling us your name and the party that you represent. Mr. Riches.
Good morning, and may it please the Court. My name is John Riches. I'm joined by Tim Sandifer, and we represent Mark Gilmore and Mark Harder, two heavy equipment mechanics who are employed by the City of Phoenix. The Court below erred on a threshold question of whether my clients fund the practice of release time. If the answer to that question is yes, which we believe it is, then this case turns on Janus and on Arizona's protections against compelled speech and association. If the answer to that question is no, then this case can be resolved under the gift clause. We think the answer to that is clearly yes, that is that my clients do fund the practice of release time. One point I think is abundantly clear and does not appear to be disputed, and that's that the union is not paying for release time activities, including its political and lobbying activities that are performed while on release time. The reason appellants are paying for release time is threefold. First, the plain language of the MOU says that they are. Second, the Arizona Supreme Court in the Cheatham decision, specifically in paragraph 14, held that release time is funded as a component of individual compensation. And third, my client's pay was in fact deducted. 8 hours of vacation leave was removed from their pay in order to fund the practice that's at issue.
Counsel, let me ask you about those first two, which are, they're not identical, but they're very closely related. It struck me in preparing for today that the MOU in Cheatham was different in a material way in that respect, that it really did say, has been charged as part of the total compensation contained in this agreement in lieu of wages and benefits. That last language, in lieu of wages and benefits, doesn't exist in this MOU. That's
true, Your Honor. We don't think that language is dispositive in Cheatham. What the record here, in fact, we tried to clarify this. It was really almost a throwaway in Cheatham. It wasn't a part of the analysis at all, but it's a difference in those two MOUs, the underlying documents. That is true, Your Honor. That phrase doesn't exist in this MOU, but it wasn't, the court never discussed that phrase as being dispositive at all. And then in the record, we did try to clarify this point. I think it's helpful, though, to point to what exactly the court does say. So in paragraph 14, what the court does say is that release time is a component of the overall compensation package and is paid in lieu of increased hourly compensation or other benefits per unit member. And I think that language in paragraph 14 is crucial, per unit member. That's the Supreme Court telling us that this is in fact financed by each individual employee. Help me on that, though, because Cheatham says that without question, but again, construing a different MOU with many similarities, but different language, as I pointed out. So you're saying that language doesn't matter, once an MOU, always an MOU. Cheatham says that means members or non-members, employees in the unit, pay for it. Right. They're substantially similar, and so when we clarified this point on the record, for example, we asked the city's budget and finance director this question about these 8 vacation hours that were eliminated in order to fund release time. So when the practice of release time was previously eliminated, each individual unit member received 8 additional hours of vacation pay, including my clients. So we asked the Budget and Research Director, why was that the case? And she said, in lieu of the union release bank of hours and full-time release positions, and that's at the supplemental appendix at 44. There's also supplemental appendix 98, which is a city explainer as to why those hours were eliminated. And that was the same exact thing that happened.
But doesn't there's sort of a historical approach to MOUs, it seems, in the record that take two different approaches, but in three different time windows, right? So the original MOUs didn't use this 8-hour vacation trail, and I shouldn't say original, but before 2014 they did not. Then they did for a time, and then those went away, and the MOU we have now does not have that provision. And it's the interim, how the interim worked, and its carryover is what you're pointing to support that argument as well.
Right. I think the one thing that's really clear is the pattern of what happens when paid release time exists versus when it's eliminated. So when it originally existed, the employees did not receive the 8 additional vacation hours. When it was eliminated in 2014, they received the 8 additional vacation hours, and we believe the record is undisputed that they received that because paid release time was eliminated. And then when it was restored, there was an interim MOU, and then when it was restored in this MOU, the 8 hours went away.
Right.
That's also consistent here.
But there's nothing in the agreement that says that at this point. There's nothing that says it's paid for by them. There's no in lieu of language. So we have to look completely outside the agreement to get to your argument. Fair?
I don't think so, Your Honor. I think
Where in the agreement do I find it?
right in section 1-3A, when it's describing how the cost of release time is handled, and it says the cost to the city for these release time positions and release hours, including all benefits, has been charged as part of total compensation. And that appears to be clear and unambiguous language, and of course, when the language of the parties is clear, we have to give it its normal meaning.
Let me ask you about a provision in your complaint, though, that says the city finances the benefits of release time to the union under the MOU.
In the same way as any government agency pays for public employees, in the same way as, for example, the school district in the Janus case before the U.S. Supreme Court, of course, paid Mark Janus's salary. And in that sense, any public employee is, of course, receiving their salary from their government employer.
And I understand that. It's just the text used there is somewhat different than your explanation, but I appreciate your explanation.
It was probably inartfully drafted, Your Honor. And back to your last question, Judge Thuma, in terms of this being a practice of the parties, that when release time goes away, compensation increases, when it's restored, compensation decreases. The same exact thing happened in this MOU with the firefighters union. That is, paid release time was completely eliminated. And what did we see? We saw the same exact thing that happened in this case. Each firefighter, whether they belonged to the union or not, received 8.5 additional hours of vacation leave. Importantly as well, we didn't see any diminution of labor services and things like that, which we'd be happy to address. If the court finds that our clients do, in fact, fund release time, then the question is whether release time serves a compelling government interest, and even if it does, whether less restrictive means can be used to advance that interest. I don't think we even get past that first question. Your Honor, the record is abundantly clear that the union uses release time to engage in political and ideological speech while they're on release time. That includes meeting with political candidates for the U.S. Senate, the state legislature, meeting with Phoenix City Council candidates. It includes meeting with the union's political action committee, which then determines which candidates to support or oppose. It includes use of release time to prepare and distribute union newsletters that then advocate for the election or defeat of political candidates. It includes use of release time to lobby the city for the union's preferred policies and practices. And the U.S. Supreme Court has been clear time and again that there cannot be a government interest in a union's political or ideological speech. The court said that in Knox. The court said that in Abood. The court said it very clearly in Janus, where the Supreme Court held that a public employer is flatly prohibited from permitting non-members to be charged for political or ideological speech. Now, the defendants might argue, well, release time is also used for other things, for filing grievances and to engage in collective bargaining and that sort of thing. Well, again, the Janus Court said that that was inherently political, but what the Janus Court went on to say is that less restrictive means have been and can be used to advance those purported government interests. And here the record is really plain on that point, because we've had a situation, we have a history that the court can go back and look to say, you know, what happens when release time is eliminated, I shouldn't say eliminated, when release time is funded through voluntary contributions rather than being compelled as a pay deduction. And so, for example, when release time was eliminated previously, the city manager was asked, have you seen a diminution in labor relations as a result of release time being funded through voluntary donations rather than through compelled payments? And the city manager testified that based on the MOU, we made it work. He also testified regarding the MOU between the firefighters union and the city, the current MOU, where release time is also funded through voluntary payments. He testified there was no diminution in labor relations. So this is one of those very clear cases where we can see, I mean, the evidence demonstrates that less restrictive means have been used.
And Mr. Riches, I don't want to cut you off, but I also know we have some significant questions about gift clause, and I want to make sure you have enough time. You know, I think one of our questions is, you know, as an intermediate appellate court, seeing what we see in Cheatham, but understanding that in light of Shires, you know, there may be some room there. Mm-hmm. How do we thread that needle in light of that? And I think that we'd all like to be educated in both parties' perspective of whether we can do that and how. Sure.
Thank you, Your Honor. I think put simply, Shires vindicated this court and this court's decision in the original Cheatham case. And what Shires said is that we can no longer defer to the government's assessment as to what adequate consideration is. And the government's whole argument in the prior case was like, well, look, we can't just look at release time on its own. We can't assess the costs and the benefits.
And I understand that, but do you think that Cheatham turns on deference to the city's calculation of consideration, especially in light of the fact that they did really show their math? I mean, they didn't just say, look, we have to give deference to the city here. They've said that the consideration is adequate. They broke it down, and they showed us what the cost was. So are we to say that Shires makes a difference in our look back at consideration without deference in a case where the numbers play out to be very similar?
I believe so, Your Honor, for the reason that the whole argument that release time can't be viewed as an independent component of the contract was really dispositive in Cheatham. And because the court found that it can't be viewed independently, which, by the way, is contrary to what the Arizona Supreme Court said in Westuber. So in Westuber, the court also examined a release time contract, and they looked just at the release time provisions, and they said, what are these costing, and what's being received in return? And in Cheatham, they did the opposite. And the reason they did the opposite was because the government defendants in that case said that they should, advocated that they should, and we know that they deferred to that assessment on consideration.
Well, it's somewhat less clear to me that they deferred to that as opposed to that they did that math. Mm-hmm. And that may be a shade of gray sort of argument that really may matter. But Westuber, you're right, was the first case that applied the gift clause, to my knowledge, to services as opposed to things. Right. We now have two, which with Cheatham, and Cheatham appears to say what the numerator and the denominator ought to be for that calculation.
Only, right, that's true, Your Honor, which again gets us back into, well, if that is true then, if that's the case, numerator, denominator has got to be the whole contract, that inescapably gets us back into the compelled speech and associational claims.
Help me understand that, because I don't read Cheatham as saying that.
Well, what Cheatham said was that, of course, this is funded as part of the overall compensation per unit member. And if that's true, if these release time positions and practices funded as part of overall compensation per unit member, then that means non-unit members are necessarily forced to finance these activities. So it's really an inescapable circumstance where if the Cheatham Court was correct, then it's a compelled speech and association issue.
Although that case didn't involve compelled speech and association.
It did not, Your Honor. The court did point out that perhaps a new case might in the future, and it referred to the possibility of those issues being brought before the court.
And so do you think that you've adequately threaded that needle as to us being the intermediate appellate court?
If the court, Your Honor, if the court says, look, we're going to do what the Westuber court did, and we're going to look at release time, and we're going to weigh the value of release time versus its cost. And if the court decides to do that because what Shire said is we no longer defer to the government on this question of consideration, then this court can thread that needle.
Thank you.
On the gift clause question as well, I think it's significant to assess objective fair market value and obligations. What the defendants have argued is like, look, there might be some benefit for release time. Maybe there's some labor peace component of it that's helpful. But of course, there's no contractual obligation to ensure that occurs. There's no obligation to ensure that the released employees sit down with the city for a certain number of meetings, that they represent employees for a certain amount of circumstances, that they engage in certain activities that they have a contractual obligation to do. And that, in our view, is fatal on the gift clause question. I'd like to turn very briefly to the fee award. The fee award in this case should be reversed. Westuber sets out a very clear policy that an award of attorney fees under Section 12341.01 in cases that challenge the constitutionality of the action of government officials in good faith is contrary to public policy. There is no basis to depart from the Westuber rule. The defendants argue, well, that case was brought by taxpayers. Westuber doesn't say that only cases brought by taxpayers on constitutional claims that challenge the legitimacy of government action in good faith, fees shouldn't be awarded. That applies to all cases that challenge the constitutionality of government action, and it is much more common that individuals' constitutional rights are violated outside the taxpayer context, just as they were in this case. If the lower court's ruling on this is allowed to stand, it will chill public interest litigation across the ideological spectrum. I think the amicus curiae briefs in this case make that plain from the ACLU and the Pacific Legal Foundation and others, that this is a fundamentally dangerous ruling that will prevent litigants who, in good faith, are challenging the constitutionality of their government.
Counsel, do you view Westuber as kind of the case law exception to the force of 12-340-101? Or are you saying that this case would not fall under 12-340-101 even if Westuber didn't exist?
Both. I think Westuber sets out the bright line rule that if citizens in good faith are challenging the constitutionality of government action, fees shouldn't be awarded under that statute. But 12-341, as the court is aware, also doesn't apply. There's case law on this. Some of it is there's case law that specifically says it doesn't apply on statutory or constitutional questions. The Pintanato case is the one that's most directly on point, and these are all clearly constitutional or statutory questions. I see I'm at 2 minutes and 20 seconds, and if it's okay with the court, I'd like to reserve the rest for rebuttal.
Very well. Thank you, Counsel.
Thank you.
Do you have a couple of appellees? Counsel, please inform me on who's speaking. And your client, of course.
May it please the court. My name is Dan Bonnet. I am representing the intervening defendant, AFSCME Local 2384 Union. Seated at council table is John Dorn and Matt Hesketh, who are representing the city and the city defendants. Given our allocation of time here for 20 minutes, we have caucused, and I am going to address counts 1 and 2 of the second amended complaint, which are the free speech and the association arguments. Mr. Dorn will be addressing the right to work and gift clause arguments and the fee arguments. With one caveat, I do have a comment at the end to make very briefly with regard to the Pacific League Foundation's amicus brief as it relates to the intervening defendant's position with regard to attorney's fees.
Very well. I appreciate that, that sort of structure. Time goes fast. So
Thank you. And I'm trying to stay at 12 minutes so I can yield the remainder of my time to Mr. Doran. As this court is well aware, this appeal, like all appeals, have to be decided on what's in the record. With all due respect to plaintiff's counsel, they've ignored, we think, substantial admissions by the plaintiffs in the record with regard to the whole concept of whether or not they are compelled to fund release time. We've laid out in detail in our brief and in the city's brief all of the information that supports the allegations that this is not compelled funding of release time. It's also important, and I think the court, Judge Toomey, you hit on this directly with regard to your observation of what's contained in the plea MOU. The in lieu of language is critical to the analysis here for a couple of reasons. One is it was explained by the city manager and Xavier Frost, who was the labor relations director at the time, that this whole concept of total compensation as it relates to this particular MOU talks about the economic package and what the city budgets to fulfill its obligations under the Memorandum of Understanding. That's different than expressly stating in the MOU that it's in lieu of wages, and I think that's a significant difference. The other thing that's critical here to the analysis is we are not looking at the whole notion of release time and how it's been provided to all of the bargaining unit representatives since the meet and confer ordinance was passed in the 1970s in a vacuum. There have been specific MOUs for discrete and definite periods of time that have covered that length of time. And that's important because once the MOU expires by its very nature, like any contract, all of the terms and provisions set forth therein are done. They're over. The next MOU that comes along is bargained collectively across the table. The parties decide what's important for that particular MOU, what needs to be included and what's not to be included. And the fact that the 2014-2016 MOU contained an 8-hour additional pay, vacation pay provision in it is a red herring. The Abbott case that the parties cite, the Bennett case that the parties cite, and the Orleafy case that the parties cite say that once those contracts have expired, there's no expectation that the benefits provided in those contracts will extend into the next one. In fact, if that were true, it would stand not only contract law, but all federal labor law on its head. There would be all kinds of problems with regard to how labor management relations are handled.
I understand what you're saying, although a compare and contrast at times can be instructive.
It can if there's ambiguity in the agreement. And in this instance, had there never been any collective bargaining agreements at all, and this has simply been perhaps by city council fiat, we're going to fund release time, then prior practice may have some traction in terms of how the parties would be dealing with one another. But here the MOU is very clear. There's nothing in Section 1-3 that talks about these 8 hours in the 2019-2021 MOU. It's gone. The plaintiffs have testified and admitted that they received everything that they were entitled to under the 2019-2021 MOU. And so it's somewhat of a constrained exercise from the defendant's perspective to see how we even get to this whole analysis of whether this is a legitimate government interest, whether it's not. The courts have spoken very clearly, even in Janus, that the use of release time to administer the collective bargaining agreement in order to maintain labor peace and harmony is clearly a governmental interest. And we cite a number of cases. In fact, every case post-Janus that we've cited also stands for that same proposition, that peace and labor harmony are something that's a vital government interest, and it's no different in the city of Phoenix as well. The city manager, and we've laid this out in various portions in our brief and the city in the brief as well, the release time is not given to the union, contrary to plaintiff's assertion, so they can go out and promote their union message. It's given to the union for specific purposes that are enumerated in the MOU, and also consistent with the union's obligation under the meet and confer ordinance to perform certain functions specifically that they're required by that ordinance to do. Negotiate in good faith for the benefit of everybody in the bargaining unit, whether they are a union member or not, to work with the city, to address grievances, to represent the interest of the employees as it relates to wages, hours, and working conditions, all of which Mr. Ayala, the president, testified is why he does what he does and what the union people on release time do. They spend more than 40 hours a week. They only get paid for 40 hours a week, but they spend more than 40 hours a week taking on their obligations. And Mr. Ayala was very clear. He says, look, what we do is to promote the best interest of what are in the best interest of the working men and women in the bargaining unit that we are obliged to represent.
So, but if we reach the idea that the union members themselves are paying for this, isn't it up to them to decide what's in their best interest in terms of their speech?
As it may relate to what the union members may do outside of the context of the release time purpose. Correct. And is spelled out in the MOU. And really what is happening here, Your Honor, I think is there's been sort of a glossing over by the plaintiffs of what the time release time purpose is clearly set for. And if you look at the MOU, it spells out in there nothing that is content or viewpoint directed. It's basically saying to the union, here's your responsibilities both under the ordinance and under the contract.
Under it, can they go, for example, meet with legislators and lobby for things contrary to the city's interests?
They can, in the interest of what we have said here, that those primarily, not entirely, but primarily have taken place on lunchtime. On Saturday, the reference to having somebody at the union.
That's a yes. They can.
They can and they have, but the city is identified, and there's nothing in the record to suggest the contrary in the MOU that amount of time is de minimis. In fact, it expressly states in the MOU that the city recognizes that those activities are de minimis. There's nothing in the record to support how much time that is spent. There's some isolated one instance where they showed up at lunch and handed out pizzas and some brochures.
That seems to be part of their complaint, though, is that there isn't anything really spelled out in the MOU, and I'm probably jumping ahead to gift clause, but the time is going quickly, that there isn't anything, when Shires tells us about the things that can't be anticipated indirect benefits or valueless for the consideration prong. So, and I think part of appellant's point is that there's nothing specific spelled out in the MOU that is guaranteed to be given back to the city. I see the policy arguments that you're making about how it promotes smoother working relationships and it gives you someone to meet with and those things, but there's nothing promised in the MOU that can be quantified for consideration purposes.
Well,
and because that's an issue that we're grappling with, if we need to speak to someone else on that, that's fine.
I'll defer to Mr. Doran in the context of the gift clause argument. In the context of the speech and association argument, I do think there is a need to recognize that the ordinance does, in fact, impose specific obligations on the union.
Right.
The MOU has specific provisions in there about what the union is required to do. So that's the contract. Those are the obligations that the union is fulfilled. If the union doesn't do what it's supposed to do, there's a procedure under the ordinance to move to have them decertified as the bargaining representative. If the union doesn't do what it's supposed to do under the terms of the collective bargaining agreement, under the MOU, there's a process to file grievances. So I would respectfully disagree with the plaintiff's characterization that there's no requirement. The other thing that's important to recognize also, and again I defer to Mr. Dorn on this, the city manager basically said, look, what we're talking about here is time. The time that this saves the city in administering the contract and doing everything we'd have to do if the union full release positions weren't there. We'd have to hire more personnel. We'd have to meet with these individuals one-on-one. There's all kinds of things. So the value of that time, I would again defer to my colleague here about how to address that.
Thank you.
Finally, my last comment with regard to the association argument is simply every court case, federal and state court that has looked at this post-Janus that we were able to find has found that even under an exacting scrutiny standard, there is no reason to find that this structure that's used to have the union act as an exclusive bargaining representative violates any speech or association right. Janus itself was clear on that. And the cases that we've cited ad nauseum in our brief in the city also all stand for that same proposition. Finally, my last point on that is that I do not believe that any of the plaintiffs were able to point to any message the union pointed out, anything that they felt compelled to associate with. In fact, they disassociated with the union. They were members, and they stopped. They didn't lose their job as a result of that. And there's nothing that the union says that's been attributed to them. The last comment I'd like to make, because I'm going to defer the rest of the time to Mr. Doran, is with regard to the issue of whether or not the status of the union as an intervener has any bearing at all on whether fees can be awarded under 12-341-01 is a red herring. First of all, it was never raised by the plaintiff in any part along in the case, so we've objected on procedural grounds that the amicus shouldn't be able to raise that for the first time. And secondly, the union is not characterized as just waltzing in here. They're a party to the contract, and they had every interest in maintaining their contractual rights under the contract. So I defer and yield the rest of my time to my colleague.
Thank you, Counsel.
Thank you.
Mr. Doran.
May it please the Court, again, John Doran on behalf of the city together with Mr. Hesketh. Your Honors, first I'd like to address the question of the 8-hour trade-off as a suggestion that somehow these appellants actually paid for paid union release time. They did not. The question here is whether this contract itself is unconstitutional. The question isn't whether a contract that preceded it is unconstitutional, or that a combination of the preceding contract and this contract is unconstitutional. There was never a provision in this contract that provided 8 hours of vacation time to these appellants. That was never taken away from them because it didn't exist. What they're complaining about is something that happened at the bargaining table, but that's not the contract, and negotiations leading up to the contract aren't what they allege is unconstitutional. They didn't pay for release time by losing vacation time because it didn't exist. I do want to point out with respect to how these individuals supposedly funded release time. The Cheatham Court specifically recognized that the employees do not fund paid release time. How do we know that? The court would never have performed a gifts clause analysis if the city wasn't paying for it as opposed to the employees paying for it. We never would have had Cheatham, but for the fact that the court recognized that it is the city, not the appellants or the Cheatham appellants, that in fact paid for paid release time. I do want to address the court's questions with respect to the adequacy of consideration. First of all, only grossly disproportionate benefits violate the gift clause, and that's from Turkin, of course. And again, there seems to be a back and forth with respect to what view we should be taking of the value of consideration. It's a panoptic view. That hasn't changed under Shiras. Shiras changed one thing, and it's a thing that Cheatham said after it conducted its gifts clause analysis. In the latter paragraphs of the opinion, somewhere in paragraph 40, I believe, the court said, oh, and by the way, we do defer to the public entity's decision-making. But the court had already concluded before it said there's a rule of deference that there was sufficient consideration. And why would there be sufficient consideration? Well, what's given here is extraordinary.
Counsel, I want to hear from you on that point, but do you view, Shire's used far exceeded as opposed to grossly disproportionate? Is that a modifier of Cheatham, or are those synonyms? They're not the same text.
They're not the same text, but I think that's probably just a language change. I don't think it changes the substance of the test, to be honest with you, because the grossly disproportionate from Cheatham comes from preceding cases, and nothing in Shire said we're changing that body of law. So looking from a panoptic view, what is it that the MOU gets the City of Phoenix? Well, it secures the services of 1,500 employees day in and day out. And by the way, those employees serve the public. Worcester and Cheatham specifically recognized this as a public purpose and a valuable public purpose. At the end of the day, every single opinion that we've addressed, every single opinion in the brief says you have to look at this from a panoptic point of view, and the panoptic point of view shows that the MOU itself gives benefits. For example, as an old-time labor lawyer, I can tell you there's nothing more valuable under the sun than a no-strike clause in a collective bargaining agreement. There's equally nothing more valuable than a comprehensive employee grievance and arbitration system. For example, let's say the grievance and arbitration system avoided just 2 lawsuits. That would pay alone in attorney's fees the cost of the actual release time. The value is inestimable, and it does raise this interesting issue, as Judge Thome explained. These are the first kinds of cases we deal with where you can't go out and say, here's fair market value. You can't actually put a dollar value on it, but as a city administrator, you actually can. The undisputed evidence from Mr. Zerker says this is a dollar-for-dollar exchange. What we are paying for is to have the union release employees come in and perform an important service for us. And that is a service that we would have to replace. You'd have to build an entirely new human resources department to cover the grievances, to cover the disciplinary proceedings. And that gets us back to release time in the micro view.
Is that in the record anywhere, counsel? Because you've focused on the record before.
Mr. Zerker,
your argument is I'm just trying to understand if that's in the record that I can.
Mr. Zerker specifically testified that this is a one-for-one exchange, and that these people would have to be replaced within the city to do this work for the city. And it's undisputed, Your Honor.
No, I just wanted to make sure that we weren't.
No, I try to stick to the record as best I can, Your Honor. I also want to point out that it's a bit of a false statement to suggest that release time itself doesn't have anything binding on the union when you look at the release time provision itself. Most importantly, Section 1.3 of the MOU includes in what it says is release time activities the defense of grievances, the defense of disciplinary proceedings, and all the things you expect the union to do on behalf of its members. And by virtue of the ordinance, they are likewise required to do so. If the union said, you know what, I don't think anything in Section 1.3 actually binds us, so we're not going to defend the appellant's grievance, that would be a breach of the MOU by its plain language. That would be a breach of the duty of fair representation that the union owes to the appellants, even though they're non-paying members of the unit. And it would be an issue for the PERB.
I just want to get to a very point that we dealt with other counsel. Can we thread a needle between Cheatham and Shire and get to their end, or is your perspective that if a change has to happen, it's going to be up at the 4th floor, it's not here?
From the moment I saw this case, I said there is no way to thread that needle. Cheatham says what it says. Shire has changed one thing, and the only thing it changed, and by the way, it adopts all of the tests, it recognizes all of the tests on both sides of the test. It recognizes everything that the courts have said before. The only thing it changes is one sentence in Cheatham after the Cheatham court concluded what it concluded, and that doesn't change anything. Because even if you try to thread the needle, our record is so profound with respect to the value of the consideration the city receives from the MOU, and even separately from the release time, that there's no way you can get through and thread that needle.
Mr. Dorn, your time has expired. I'm going to give you and appellant both another minute. We would like to hear from you on the fee issue, and then appellant will have 3 minutes and 17 seconds.
Thank you, Your Honor. Very briefly, all I'll say on the fee issue is, first of all, statutory and constitutional claims are subject to 12-340-101. We know that from Ask Me and Pacholi. Secondly, there's been a great deal of talk, particularly in the Yemisi, with respect to the chilling effect. The only thing that really should be chilled here is when you have two individuals who know nothing about their case, nothing about their claims, and nothing about the facts as your representatives in a public interest litigation. That should be chilled, and this is precisely the kind of case that Judge Wake spoke about in the Coleman decision, which we cited. Once the plaintiffs had testified under oath and eviscerated their case, this case should have stopped. They should have thrown their hands up and said, we're done. That's the activity that's being chilled. Nothing else. Legitimate public interest litigation will continue for time immemorial. Thank you, Your Honors.
Thank you. Mr. Riches, you do now have 3 minutes and 17 seconds for rebuttal.
See, it was automatically adjusted. Thank you, Your Honor. Just a few points. The union argued that, well, release time isn't just given to the union to use as it sees fits. There's controls in the contract. That's simply not true. Where in the contract does it allow release time employees to do political activities, meet with political candidates, meet with political action committees, engage in lobbying activities? And in fact, the record is really abundantly clear on this point. These release time employees don't report to the city. They report to union headquarters. They don't have supervisors, unlike any other employee in the city. They don't receive performance evaluations. They don't provide an accounting of their time. So the reality is, we don't know. We do know they're engaged in a lot of political and lobbying activities, but the city also doesn't know what else they're doing when they're on release time because it writes them a blank check to do that. Second,
Where in the record do I see that they absolutely engage in political activities?
It's throughout the record, Your Honor. I would point you to the Appendix 40, Supplemental Appendix 50 to 55, Appendix 22, Supplemental Appendix 53, Supplemental Appendix 68 to 70, Supplemental Appendix 60 to 63. All of those are the extensive political and lobbying activities of these employees. And importantly,
Trusting someone else could take it down faster than I can, but we can always replay the tape.
and importantly, we're not talking about, and you asked Judge Gass, well, can't these union members, decide what kind of activities they can engage in? Sure, but they can't do it at the expense of non-union employees. And in this particular bargaining unit, there's only 641 union members. That represents 1,300 employees. So more than half of these employees have elected not to be represented by this union, but they're funding its activities anyway. The defendants made a lot about the record and about appellants purportedly not objecting to the use of release time. That is emphatically not the case. In the record at Supplemental Appendix 108 and 109, these appellants specifically state that they object to use of release time for political activities, recruiting activities, grievance procedures. They're well aware of what release time is used for, and they object to funding it. Third, Mr. Doran said that, look, the question isn't what some prior contract meant. That's true. The question is what this contract means when it says the cost to the city for these release time positions are funded as part of total compensation. And in this contract, the additional compensation in the form of 7 vacation hours was eliminated. To the gift clause, just very briefly. Valuation means measuring release times benefits to the public, okay, to the public. And Shire said that we must know what that means. Mr. Doran said it's inestimable. Well, whether that's the case or not, it's not objective. And what Shires and Cheatham and Turkin tell us is there must be an objective fair market value. And the record is indisputable. There is no objective fair market value. The purported interest in labor peace can and has been achieved through less restrictive means. And we must look at the reality of this transaction. And the reality of this transaction is release time is not funded by the union. It's funded by our clients.
Thank you, Counsel. Counsel, we appreciate your presentation today. We appreciate your briefing. We appreciate the amici briefing as well. You've given us much to think about. We'll take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.
Thank you, sir.
Thank you, Your Honor.